I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, with liberty and justice for all. Thank you, Senator. I was getting ahead of you there. Representative Dargy, how you doing? Senate Judiciary is now in session. Representative Senator Dargy is going to introduce 1260. How you doing today?
Very good, thank you.
Good.
Thank you, Mr. Chair and members of the committee. For the record, I am Representative Paul Dargy from Hillsborough 43, the town of Milford, speaking in support of HB 1260 that's titled Relative to Marriage Registration Forms and Delayed Certificates of Marriage. I've distributed copies of my written testimony, and this oral testimony is an abbreviated version of the written testimony. This bill has three main sections. The first section is to allow for marriage registration forms to be completed outside the presence of the city or town clerk, and then to be finalized in the presence of the clerk. It also allows the form to be completed by using a fillable PDF or similar document, instead of requiring that a printed form be filled out using handwriting. The second main section adds a $25 fee to complete a delayed certificate of marriage. And the third main section updates all relevant statutory language in the chapter to be gender neutral. Section 1 of the bill, marriage registration forms currently need to be filled out in person in the presence of the city or town clerk, which is a complication that is unnecessary. It can cause delays and data accuracy problems. This bill allows the form to be completed away from the city or town clerk, but still requires that the two applicants sign the form in person. The bill also allows a fillable PDF version of the form to be created and used, but does not mandate that it be done. Section 2 of the bill, a delayed certificate of marriage is required when the formal registration of the marriage has not been completed by 6 months from the date of marriage. Delayed certificate of marriage is a fairly complicated procedure that is designed to ensure that the marriage did properly occur and that everything is on the up and up. This procedure is time-consuming for the clerk, requiring efforts over and above the normal certificate of marriage process. Applicants are currently charged $50 for a marriage license, while there is currently no additional charge for a delayed certificate of marriage if one is needed. This bill adds a $25 fee for a delayed certificate of marriage, with the fee retained by the city or town. This is an attempt to charge the applicants a fee that roughly pays for the additional work required of the clerk to process the delayed certificate of marriage. Section 3 of the bill, this portion of the bill was added to the bill by amendment. Many sections of the RSAs that address marriage are not gender neutral, using terms such as bride and groom. And the series of changes included in the third section attempts to make the relevant RSAs gender neutral. This bill passed the House Judiciary Committee on a vote of 17-1 and was then passed by the House on the consent calendar with an OTPA motion. This is a straightforward bill, and I urge an OTP motion on it. That concludes my testimony. Thank you, Mr. Chair, and I'm available for any questions.
Just a quick question. Were you asked to bring this bill forward? Or was it something you thought of? Or?
Yes. My wife is the town clerk of Milford, and she's past president of the New Hampshire City and Town Clerks Association. And the City and Town Clerks Association asked for this bill to be brought forward. The first two sections. The third section about the gender neutral things was not part of the request.
Okay. Questions, Senator? None at all. Okay. And just personal question, you don't have to answer me. The gender neutral, is that, do you like that, or?
Oh, yes. Yeah.
It's the time. Okay. Thank you very much.
Yeah.
Representative Horgan, good to see you, sir. How you been? Come on down.
I am Representative Timothy Horgan from Stratford County District 10, which is the town of Durham, and I'm a member of the House Judiciary Committee who added the gender neutral language to the bill, so that's making Representative Dargy's excellent bill even more excellent. And so I'm a member of the Minority Caucus. As you know, we had some doubts about what our friends in the Majority Caucus were going to do, but we went ahead and I went ahead and I was tasked with asking OLS to draw up a gender neutral amendment to the bill. And we didn't know whether And then on the day of the executive session, we discovered the Republicans had the same thought, and they felt positively about it. So we ended up with two competing amendments, which were exactly the same, I think, except for the number in the upper, I guess it's the upper left-hand corner. And actually then, if you look at the docket for the bill, ended up having the name of one of the reps from the majority caucus and then the chair and the ranking member. So I think that's a good step forward. I think marriage equality was a large step forward, one of the most important things I've been involved in all my years in the legislature. And it was good to have it's always good to have a moment of bipartisan shift this year, but also over an issue which, even though marriage equality was quickly accepted by the people, is still something that there's still some lingering controversy over. So I was glad to say that. And I guess we haven't gotten to the amendment yet. So it's in order. I did sign in neutral on that. So do you want me to address that, or do you want me to get up and be recognized a second time for?
I have a question. Does OLS, I thought they were doing, I thought they did it on their own, like gender neutral. I thought they were doing that all on their own.
Well,
it's not, obviously.
There's like a general, I'm not sure how to answer that, but I mean, yeah, I think a group of reps or a committee has to ask for it. There's been a long-standing thing for a number of decades, making as many things gender neutral as possible. So this, I think for us, when we were looking at the bill, when I was looking at the bill, there was just one section. There's this one section where that issue was obvious, and then we went and looked through the RSAs and discovered there's like many other sections. So we figured now is the time to fix it, and so
we're all set.
Fix it.
Thank you. Thanks for coming up. Appreciate your
Thanks.
testimony. Anyone else wish to testify on 1260 who didn't sign in? Seeing none, that'll end the hearing. Thank you. I'm going to sit and listen to you, and I'll rule on it right away. But I know your enthusiasm, Representative. I'd like to see it. It's good. Senator Reardon, go ahead.
Good afternoon, Chairman. I am here to introduce a non-germane amendment to HB 1260, and it's amendment number 2026-1173S. And it is relative to confidentiality of divorce records. So surprisingly to me, if you ask a court to seal a divorce record, it is unlikely to be granted in the state of New Hampshire, and that is thanks to a case from 1977 called Thompson v. Cash, and then reaffirmed in a case by the Keene Sentinel after that sought to have divorce records opened. And it relies on two sections of the New Hampshire Constitution. Part 1, Article 8, which rightly says government should be open, accessible, accountable, and responsive. And to that end, the public's right to access to government records or proceedings and records shall not be unreasonably restricted, is the words that the Constitution uses. So this bill asks, in very limited divorce cases, and those limitations need to be that there are no minor children at the time of divorce. It's an uncontested divorce, and the parties themselves reach an agreement and both sign that they would like to have the records sealed. And the records that are sought to be sealed are not a record of the divorce, of the date of the divorce, or any of those things that you would expect to be able to indicate, find in a public record. But it's about what you own, how much debt you have of what you own, the percentages of ownership, and other information that isn't reasonable that it should be open to the public. So in the divorce records under this amendment here, financial affidavits, tax returns, financial statements, property settlements and stipulations, exhibits, documents, assets, liabilities, or financial position of the parties would all be redacted, and also account numbers or identifying data so you can find it. So at this time, if you have a divorce in the state of New Hampshire and you have substantial real estate or financial holdings and you come to an agreement with your spouse, all of those are going to become public. And at the time of Thompson v. Cash in 1977, or the Douglas divorce hearings, which were the Keene Sentinel cases, there was no such thing as the internet. And now you can be sitting in Peru and look up a New Hampshire divorce and get all of that information, all of that financial information about a person. So it's not only susceptible to identity theft. We heard a bill the other day about fraudulent sales of property, but it leaves the parties open to even unfair information in business dealings and stuff, or something like that. If you were going to buy a property from somebody who was recently divorced, you could go to their divorce record and find out more information than you would find in any other way. So this amendment, while protecting and redacting those pieces of it, still keeps all of the information about when the marriage is dissolved, the date of the decree, the court issuing it, and any other non-financial terms there. And this wouldn't even apply if the court found that it was in the public's best interest for this information to be open and available. It does cite directly from the Thompson v. Cash holding in 1977 on page 2, lines 25 through 29. Those lines right there are exactly from that case. A compelling public interest that requires disclosure. The request is narrowly tailored, and no reasonable alternative exists to that. It goes on to provide rule-making authority to the courts. And lastly, it provides that any divorce within the past 15 years could file a request to have their financial information redacted out of that. That's it.
So question for you, Senator. I haven't reviewed this in a week, but so you're one of the parties to the divorce. You want it sealed. I could be someone you owe money to. And that would be an easy place for me to, if I could look at those records, I might see that you have a lot more assets than you're letting on. So aren't you denying possibly people who have a right to know this knowledge by sealing it?
So I think in the normal course of businesses, creditors, and that's who you're referring to, a creditor of somebody, has methods to find out what people own. They can review registry of deeds, records, anything like that, but it won't actually give you the balance on mortgages or the what percentage, if you have a partner, what percentage of something that you own. So you're making it easier for a creditor, for somebody who's in the middle of a divorce, than you would be for any average debtor that they would be seeing. So a little bit of an unfair advantage there. If you're getting a divorce, you're more susceptible to creditors. But in fact, creditors aren't the issue. It's fraud. That's the issue, that anybody could look and see your list of holdings. They could call up to sell one of your property and make references to, who your bank was and what other things that you owned or what percentage you owned, as if they were you and could impersonate you.
Good enough, Senator. Any other questions? Seeing none, thank you for your testimony. Representative Horgan again. You're 2 for 2 today, Tim. Well, I guess see you all day, which is fine. Just asking.
So I continue to be Representative Timothy Horgan from Stratford County District 10. So I just checked off neutral because this is a fairly complex bill and it makes a significant change to the law. And I'm somewhat agnostic of whether or not it's a good idea. I think the basic concern is extremely valid. There are ways to address those issues without changing the law, and that might be best to leave it alone. My major concern is I just think the underlying bill has its broad bipartisan support. I think it's probably best, from my perspective, as someone who worked on getting the underlying bill passed in its current form, to have it, go back through the process without any amendments, so then it can head straight to the governor's desk for her to make her decision rather than going through the conference committee. Then the amendment it's a good idea. Probably my preference would be probably just to have it introduced in a future session as a standalone bill. Then it can go through the whole process in both chambers. But I'm neither at this point opposed or in favor of the amendment. So that's I'm just expressing what my preference is as one member of the other opposite legislative chamber from yours. So I'm sure you'll make a wise decision either way. So thanks.
We try. Thank you. Have a good day.
We can't guarantee it.
No guarantees. Anyone else wish to testify on the amendment? Seeing none, we'll end that hearing. Almost. Representative McFarland, are you here? There you are. Okay. Come on down. So we're doing 1108.
Yes, thank you, Mr. Chairman and the colleagues and the committee members. Thank you for the opportunity to introduce HB 1108. For the record, I'm Representative Daniel Popovich Mueller from Windham. I'm introducing the bill because the prime sponsor asked me to apologize. He's out of state and unable to introduce the bill himself. But as a co-sponsor and after the work I've done this morning to prepare, I'm very comfortable talking about the bill. To make a long story short, this bill had a bit of an up and down path in the House. It came out of a committee with a 13-0 ITL recommendation. It was pulled from consent. And then the vice chairman of the committee tabled it with a commitment to address the language. It was addressed and it passed on a 193 to 144 vote on the floor. What the bill does is that it changes the definition of, basically it replaces a portion of the law that describes what is a accepted display of a firearm in order to deter from a threat. The current language says that in order to do that legally, you have to respond to a threat that is likely to cause bodily injury or death. The language as passed by the House changes that to conduct that could be perceived as likely to result in bodily injury, death, theft, unlawful intrusion, or refusal to leave after lawful trespass notice. So the reason for this change is that there is a gray area in the law where people who find themselves in a situation they perceive as dangerous to them may be unable to de-escalate the situation by just showing that they are armed, without pointing it, without threatening anyone, right? And this is already allowed in the law, but there is a gray area. And the House, the vast majority, well, the majority of the House, including some Democrats on the floor, there was a roll call, agreed that this extension is desirable. And since I introduced the bill, I'll be happy to stop and answer any questions you may have.
So it's always going to be subjective because could reasonably, right? It's going to be a hard thing to pinpoint what's reasonable. It's always going to be something in a courtroom we're going to decide reasonable. So we'll have to look at the circumstances of every time. So then if it's reasonable, you can display. So I'm assuming when you say display, you're not mean, it would depend on the circumstances, what's reasonable, correct?
Yes, sir, it
Whether
always
you're
does.
just flipping your coat aside to let someone know, whether you're taking it out, whether you're lifting it, raising it, pointing it.
Well, actually, the display
Yeah.
does not allow, pointing it or waving it around. It just allows the display. Basically, it's a polite way of saying, I can defend myself if this escalates, let's not escalate. Any aggressive language, any aggressive behavior would absolutely not be covered under this. This is
It's just
strictly
display, you're just letting
just
them know you.
display. And if I may provide a quick example.
Sure.
I was in Hanover. My wife was a graduate student at Dartmouth College during the 2001 Zentop murder.
She's very smart, okay.
Well, she's the smarter person of the family. I want to say that on the public record.
I have the same thing going on in my house.
So, but basically, the two murderers, before they murdered the Zantop family, who were two very kind professors who believed everybody was great and tried to help them and actually invited them into their home, the two murderers went to several other houses. They had 4 or 5 previous attempts, and in none of those attempts they were allowed in the house. But I was told at the time, as you can imagine, this was the talk of the town, that at least in one of the cases where they tried to gain access to a house by pretending their car broke down and they needed to access a phone, they wouldn't leave when asked, and they keep banging on the door and, come on, let us in. And the homeowner lifted their sweatshirt they were carrying inside the waistband. Everything ended, they turned around, walked away, and unbeknownst to him, the homeowner saved his life probably at that time. Now, under the law as it is written today, courts could argue, was that really, the current language says, sorry, I got to scroll, it would have to be likely to cause serious bodily injury or death. I would argue that's not a standard that is met in that particular case. But if I'm a homeowner and somebody who was told to leave my property doesn't want to leave, to me, that's a very legitimate place where I can say, look, you really got to go. And the other thing that I'll say very quickly is that I live in Windham. Police can be there in 2 minutes. Plenty of people in rural areas of the state have to wait 20, 30 minutes for the cops to arrive if they ever arrived. You cannot just say, stay in the house and call the police every time. And again, this is meant just to be a de-escalation. Sorry for a long answer to a short question.
So with displays, it's in my holster, I take it out and I'm holding it by my side. Is that still just display?
I would argue that that's something that only a judge could say.
Okay.
In my case, the intent is to allow display without any threatening or any aggressive behavior. Whether a judge will consider taking it in, personally, I would probably be concerned about that. I would say that I would only cover opening your coat to show the holster.
Okay. Other questions? Senator Elcho.
Thank you, Mr. Chair, and thank you, Representative, for taking my questions. In the example that you used in your testimony, wouldn't the Castle Doctrine apply there? This wouldn't be necessary?
I am not a judge, so I don't think that the Castle Doctrine would apply in that case, but I don't think that the Castle Doctrine would apply in this case because of the higher threshold that is needed to invoke it. At the time, with the previous attempts before the Xanthops, it was hard for anybody to say my life was at risk when somebody just wouldn't leave. They kept knocking on my door, and I told them to leave, and they say, please let me in. There was no threat. They were just trying to convince people to let them in. So I think that this is necessary to clarify the circumstances in which people can de-escalate a potential confrontation through displaying a means of self-defense.
Can I follow up?
Yep.
Yes, thank you. So you've testified that this is inspired by a situation where you believe that the castle doctrine is unclear and that the homeowners who felt threatened should have been able to display their firearm to deter the people trying to enter their home. I don't necessarily agree because I think the castle doctrine is pretty clear, but how would that apply? If that is the inspiration, why is this legislation written to apply in all circumstances, not just in the defense of their person in their home? And additionally, with that, if it's meant to be broad, and it seems like it's meant to be broad, is not the display, like the intentional display of a firearm, an aggressive move in and of itself, particularly if you're using it in the way that's outlined in this bill?
So I'm going to start by saying that I did not testify that was the intent of the bill, that it's only about a limitation in the castle doctrine. The castle doctrine reference was in answer to a question about that specific point. This is intended as a broader measure rather than that. So, I'm not the prime sponsor, but I'm sure that their intent was broader than that. But as I said earlier, this is not a threat because it is intended as a calming measure. It is intended as a calming measure, as a way to de-escalate. Look, it is very tricky when you carry a firearm and you make it visible. You are at a serious risk of being perceived as brandishing, right? And it's always an interesting question in front of a court of law whether a visible firearm is brandishing or not. So the intent of this law is to clarify under which circumstances displaying is a acceptable method. We already have it allowed, right? The current statute already allows it in certain situations, so we already know that's not a threat because then we wouldn't allow it in those situations, right? And this is just looking to expand that to other situations that could lead to violent outcomes. Again, it's not safe when you are on your own property and you're telling somebody you're on private property, please leave, and they're like, I'm not leaving. Very often that's a precursor to violence.
Senator Adams.
Thank you, Mr. Chairman, and thank you for taking my question. So under my understanding of New Hampshire law, in some circumstances, displaying a firearm would be deemed reckless conduct. And under that law, Roman numeral 5, it's RSA 631:3. The act of displaying a firearm shall not in it of itself, without additional circumstances, constitute reckless conduct under this section. So what I'm asking is, that law kind of takes into consideration the mere act of displaying it is not a crime. It just factors in all the surrounding circumstances, right? Someone trespassing, the top of your driveway versus at your front door, totally different story, right?
Yeah.
Someone that's breaks in houses in your bedroom, different story than they running out the doorway, right? I'm just explaining this by expanding it to allow it for trespass and unlawful intrusion. I'm just wondering what are we accomplishing here that's not already addressed under the law? Because the law allows all circumstances to be taken into consideration.
It does allow circumstances to be taken into consideration, but if you look at the current statute, it seems to imply that the only time when a display intended to de-escalate is allowed is when we are in a situation likely to cause serious bodily injury or death. The attempt to change this, the bill changing this to not just serious bodily injury and death, but also unlawful intrusion and refusal to leave after lawful trespass notice, which is not the same thing with merely trespassing, by the way, right? If somebody's on my property, they could be lost. They could be unaware they are trespassing, you know? Nobody says display a firearm at them and that's okay. But when somebody is told you're on my property, please leave, and they refuse to leave, that's a very different situation. So the intent is to clarify the other situations where a display is allowed that would not be considered, you know, criminal threatening.
All up, you all set?
Thank you.
All set, Senator Reardon?
Thank you.
Very much for your testimony.
Thank you.
Appreciate it. Aubrey Friedman. Good to see you today, Aubrey.
Mr. Chairman, committee members, Aubrey Friedman, I live in Bridgewater. I speak in support of this bill. As I see this bill, it is an expansion of your right to defend, but I would say it's more a property rights thing. It's definitely talking about theft and, unlawful intrusion and refusal to leave when you give a lawful order, you know, to leave your property. So we're talking about on your property. That's how I see it. And I think that's a legitimate extension of your right to defend your property and diffuse the situation to deter someone from, it could definitely get into a more serious situation where it would be serious bodily injury or death. So it's deterrence. I think deterrence is a great thing. And I have an article here, I'll attach it as part of the backup, that, you know, gun violence, we see all that stuff in the news about, you know, all that stuff. How about all the times when somebody produces a firearm and just showing it, the deterrence factor right there prevents a lot of crimes that we don't hear about. In fact, the one article mentions like over 2.5 million incidents per year in the United States. That's over 6,000 per day. Crimes that are didn't occur because someone produced a gun or, you know, showed their firearm. You know, deterrence is a big thing. The unseen part that we don't see on the news. The other thing is one of the phrases that was added, unlawful intrusion. This, to me, seems like a pretty serious situation. If they break into your house, what's going to happen next? To me, we're going to probably end up with serious bodily injury or death. So I think that's not a non-lethal situation. That's a pretty serious situation. And we would want to deter that, just try to scare them away. So I think that's a good thing. And my last point is, again, this business displaying, it's clearly not brandishment. You know, you're not waving the firearm in somebody's face in a threatening manner. You are simply displaying it. And simply displaying it will scare away a lot of would-be criminals. Not all, but I think it really is effective, just seeing that they are armed. So those are the reasons I support the bill. This extension to our property rights. Thank you.
Thank you. Senator Auerschler.
Thank you, Mr. Chair. Thank you, Mr. Freeman, for taking my question. How would a person display under this law? Like what would?
Just showing it, that was mentioned just so that the person could, yeah, the attacker or would-be attacker could see it. You want to be able, whether you have it on a holster, you just show it, even if you take it, literally take it out of so they can see it. Again, not waving it or anything like that, threatening. You want them to be able to see it in any way possible, however it might be attached to you. Display is display. You want them to see it, however that might be accomplished, but not in a threatening manner.
Okay. May I follow up?
Yes, ma'am.
Where would the line be between display and brandish?
Well, brandishing, when you literally start moving it around, that to me, goes into the, that's no longer displaying in my thing, literally moving it. If you just took it out of your pocket and just held it, like pointing it at someone, that would also be another going over the line. Just taking it and holding it, or basically just showing that you've got it. So moving it around and pointing it at the person, the potential, that goes beyond display in my mind.
Senator Abbas.
Thank you, Mr. Chairman, and thank you for taking my question. So, removing your firearm from a holster is an overt act that you've now done. If you're not going to point it and intend to use it any other way, I guess at some point, I assume if a person's removing their firearm from their holster in a defensive manner, it's for a reason. So, you don't think that goes beyond displaying a firearm? At least in the example that you gave, the facts,
Well,
the surrounding circumstances that you provided in your hypothetical.
If they couldn't see it, I mean, you just want them to be able to see it. And maybe it was hidden in your clothing or whatever, and they couldn't see it. Just taking it out and holding it down. That's not brandishing. That's not threatening, I don't think.
Follow-up?
No follow-up.
Okay. Thank you, Albert.
Thank you.
Have a good day. Representative Horgan.
Thank you very much. I continue to be Representative Timothy Horgan from Stratford County District 10, which is the town of Durham. And so this is my third and final appearance here of the afternoon, but I see plenty of other people up here to testify. So I'm opposed to this bill. I was opposed to it. I was opposed to it in the House. There was a lot of activity about it, and the section of the RSA that's amending. I took a minute to look at the old bill docket passed in 2010. So I've been here so long. I was around back then. The issues were the same back then, but it was a somewhat different era. Interesting. There's a lot more bipartisan crossover on this issue, both in my chamber and in your chamber, much more than there was last month when we considered HB 1108. So anyway, so I do understand this is a gun bill. That's a very emotional topic. It involves the Second Amendment and all that sort of thing. But I think the law that's on the books, I think that's adequate. We're often reminded New Hampshire is the safest state of the nation, and they usually credit that to their gun bills. So I'm not sure why we want to change our gun laws if we're already the safest state of the nation. But this greatly expands the situations in which you can legally display a firearm. And so it's not just actual bodily injury or death, but it's just even something as simple as just theft or simply like unlawful, refusing to leave. And I think that's probably like overly broad. I mean, if the intruder is threatening you, I don't see why this bill is necessary because, there's also this language in here right at the end, which they're adding, nothing in this section shall be construed to limit the open carrying of firearms as otherwise permitted by law, which I think, I think that was intended. I think maybe I shouldn't impute motives to people, but the intent in my mind seems to be they're primarily thinking about, the property owner, although I'm a renter, so I don't know if it protects me if somebody comes to my house and annoys me, but it also, the person who is, the person on the other side, the one who is perceived as engaged, as threatening seriously bodily death, or also like these other things we want to add, that person may be open carrying a firearm in conformance with New Hampshire law, in conformance with federal law, and of course, the Second Amendment. So that may actually limit that may actually create problems for somebody who doesn't want somebody open carrying on their premises and says, sir, we don't want open carrying of firearms on this property. So could you please either conceal your firearm, put it in your car or whatever, and they can say, oh no, I have the right. I have the right to open carry. So then that becomes an issue of whether or not open carrying your firearm, whether that's something that property owners or even renters are allowed to object to or not. So I think, I just think this bill makes an already difficult area of the law even more difficult. So my recommendation is to find it inexpedient to legislate and leave what's on the books on the books. So thanks.
Thank you, Representative Horgan. Any questions?
All right, thank you.
Seeing none, thank you very much. Penny Dean. Ms. Dean, I always look forward to hearing you. You have a vast knowledge in this subject area.
For the record, my name is Penny Dean. I'm a private attorney, and I'm admitted in Maine, New Hampshire, Massachusetts, DC Circuit, the U.S. Supreme Court, 3 federal courts, and several other places. And I rise in support of this bill, and this bill is desperately needed. And it's needed as a practical matter for several reasons. Number one, innocent people get prosecuted all the time. You look at the Ward Bird case, which is what brought us in a series of bills. And you talk about, number one thing is that action beats reaction every day of the week. There's no question. And so I think having a firearm in your hand to display it very clearly is the safest and best way to deter action. And they talk about the police being close. I had a case that I came into late out of Pittsburgh, New Hampshire, and this woman who had recently had a knee replacement had 2 brothers who were spitting at her and threatening her. And she called the police. 2.5 hours later, they came. The only reason she was okay is a male friend of hers happened to come up on her, and those 2 boys didn't want to mix it up with him, so they decided to go find other fish. But what you have to understand, even in this state, which is safe, there's areas that cell phones don't work perfectly. I can tell you I travel a lot all throughout the state. Many parts of the road, there's no cell phone service. So that's number one. But number two, what you're doing in this case is making people who are defending themselves have an opportunity, a better opportunity for what's called a notice of affirmative defense. They still might charge them, which isn't right. Hopefully this will keep them from charging them. But it makes the notice of an affirmative defense a better chance for the lawyer so that you can be acquitted for what you shouldn't have been charged for to begin with. But I would recommend all of you look at the Tueller drill. Tueller drill is a very famous case, and it was a theory from Sergeant Dennis Tueller of Salt Lake City, Utah in the 70s. And he wrote an article, How Close is Too Close? And when I tell people this, until they've participated in the drill themselves, they don't believe it's true. At 21 foot away, a man with a knife will stab you before you can get your gun out and defend yourself. It'll happen every day of the week. And Masad Ayub, who's an infamous, very famous from this area, Grantham, New Hampshire, Concord, New Hampshire, firearm instructor, started having every one of his LFI classes do the Tueller drill. And even people with a walking cane will be able to stab someone 21 foot away before that person can draw their firearm and shoot them. And so this is absolutely necessary. And it does expand and make clear what I believe the original intent of the law it's replacing was to do, which is to make it very clear that when you are lawfully present somewhere, that this has to be allowed. And the Castle Doctrine doesn't support it. And to answer one of the further, a couple objections, you have to be able to move. You have to be able to draw it out of your holster to make it very clear and display it to the other party. And I'm not talking about pointing and waving, I'm talking drawing. The second thing is, if someone doesn't want you on their property, criminal trespass still applies. So in addition to getting charged with criminal trespass, the police can go through a whole plethora of actions against you if a firearm owner refused to leave someone's property. And I don't see people doing that. In general, people that carry firearms know that there's all sorts of enhanced penalties that apply to the same action every time you have a gun. And so what that makes is people be extra polite. I know when I'm in the grocery store, if someone cuts ahead of me, ma'am, please go ahead. I don't say, hey, I was here in line first, because I know that if anything came about, they'd say, oh, it's because she had a gun, or oh, because she was going to draw a gun. So what this does is simply let law-abiding people have an opportunity to defend themselves and hopefully not have to defend themselves in the courtroom again. And I'm happy to take practical questions.
Senator Evans.
Thank you, Mr. Chairman, and thank you for taking my question. You mentioned the Byrd case,
Word.
and now going down memory lane, I think in 2021, it was Representative Welch who filed HB 631:3. Sorry, it was HB 195, which amended RSA 631:3 to address that exact case. And that's the law on the books today.
I don't think it still addresses it completely. I'm not saying they didn't have good intentions. I'm not saying that isn't what they wanted to do. I think this solves that situation in a more practical manner. Because the word bird thing was that on your own property thing. But I don't know about you, but I don't stay at my own property every day. I mean, like I came here today, I'm going to go to the bank next, I'm going to go pick up a rug, I'm going to go to the grocery store, I'm going to, like all of us, do a bunch of things. And so we're in a variety of places. And so I believe at the time that that wasn't strong enough language, and I've seen that happen. And I think, could you remind me of what year Ward Bird was? 2010. I'm just trying to think. I'm trying to think of the Stuart Uri case out of Milford, how that sometimes I've been doing this maybe too long or not long enough, and I can't correlate things in my mind as far as what happened when. But I can tell you right now, as a practical matter, they're still bringing these cases. And so the answer is, this to me was the larger issue. Ward Bird wasn't just on his property, it was a larger issue to some people. When can you defend yourself from someone who just won't leave you alone? At what point does merely showing a firearm put you in the hoosegow, if you will?
Thank you.
Any questions? Seeing none, thank you for your testimony.
Thank you.
Officer Imatucci. Good to see you, Matt. How you doing?
Good afternoon. My name is Matt Amatucci. I'm a captain with the New Hampshire State Police. I just have a couple of comments to make and then a couple of questions or scenarios for the committee to consider. So the threat of deadly force during a non-deadly force scenario could result in greater number of negligent homicides. Expanding the firearms access under this legislation could heighten these risks, creating scenarios where individuals who display firearms during non-deadly force situations. This escalation introduces a serious threat to public safety and increases the potential for violent outcomes. So theft, unlawful intrusion, or refusal to leave an unlawful trespass notice are all non-deadly force scenarios. Introducing deadly force into non-deadly force scenarios could have grave consequences. So the first question I'd pose is, if an individual displays a firearm and the other individual is not deterred, what happens? And the second question I would pose is, if an individual steals from a store or trespasses onto someone's property and the owner displays a firearm to deter the individual's behavior, which could be perceived as deadly force, does the individual who is committing the theft or trespass have the right to defend themselves from what they perceive to be the imminent use of deadly force? I think that those are questions that this committee needs to think about, introducing deadly force into non-deadly force scenarios.
You're all set. Yes, go ahead, Senator.
Thank you, Mr. Chairman, and thank you for taking my question. I presume you were in the room for the testimony of the prior witnesses on this, on HB 1108. And for police officers, is there a scenario where would you take your firearm from its holster and I guess not point it? Like, what are the scenarios that an officer is allowed to do that?
Thank you for the question. Previous testimony talked about action versus reaction. I completely agree with that statement. When you display a firearm, I don't know that will de-escalate a situation. I think that it could actually have the opposite effects in many circumstances. When law enforcement is called to, you name the call, they respond to a domestic, they receive certain information. We are always asking, are there any known weapons? We're trying to gather as much information as we can. And when we arrive on scene, we're trying to, as quickly as possible, assess. And part of that is, are they complying with commands? Are they listening to what we're telling them to do? And if they're not, then, and we don't know if there's weapons, you very well could pull your sidearm out. And again, going back to the action versus reaction, that 20-foot gap, we're trained that in the academy. Those are real things. But again, we're talking about non-deadly force scenarios when you're talking about theft, when you're talking about trespassing, unlawful intrusion. Those aren't deadly force scenarios. And now you're introducing a deadly weapon into a non-deadly force scenario. And those are the things that I think that this committee should consider.
Follow?
Thank you, Mr. Chairman. And thank you for taking my follow-up question. So this would add theft to the scenario where you can display a firearm. In a scenario like that, if you were responding to a call because of a theft, I mean, I understand police officers, many of them, they open carrying, so arguably that's displayed. But I mean, in a scenario like that, when you just engage a subject, you wouldn't normally remove your firearm from its holster, would you?
No.
Thank you.
Can I just work with your hypothetical for a second?
Yes, sir.
So we'll just say someone your size and someone Miss Dean's size who testified before you. She's 20 feet away. She looks at you, young, strong guy. She feels she's at a huge disadvantage and she just wants you to know she can defend herself. And if she didn't, if you're within 20 feet and you can get there that quick, her only thought is that if I have this out, I can defend myself. She's not looking, I know she's introducing deadly force into the situation, but she's at a disadvantage to you without that gun. And so she's just thinking it's a protection for her. So I'm trying to see her versus you. She brandishes, not brandish, I'm sorry, I didn't mean to say that. She displays. She takes it out of her holster so you are aware it was in her coat, or she just lets you know she has it. So at that point, she has somewhat introduced deadly force, but it's only because she feels she couldn't match you on a physical. You could kill her for all she knows.
So thank you for the question. You have to be able to clearly articulate that you are in fear for your own safety, or you're defending a third person from what you believe to be the imminent use of deadly force. And there are scenarios where you could articulate that. But let's just say that I show up and the individual that's displaying the firearm is 6'7", 280 pounds, and they display the firearm and I'm not deterred and I start to advance toward them. What occurs at that point? Are they justified in shooting me?
They probably not, because they wouldn't reasonably perceive you as likely to deter the 6'7" strong person. Should be reasonably thinking that they could.
These are scenarios,
So,
and what I don't know is maybe that 6'7", 280 pound person has unknown medical condition.
Sure.
And, but those are the scenarios and the situations that I think the courts should hear. I think that just the layperson in broadening this statute could have severe unintended consequences. And it also doesn't talk about it's your property, and it doesn't talk about, so if you see a kid stealing a bicycle, it doesn't say that it's your property in this scenario. So where is the line in this statute?
Gotcha. Any other questions? Seeing none, thank you, Mr. Amatucci.
Thank you.
Have a good day. Does anyone else wish to testify on 1108? Seeing none, we'll end the hearing.
You know what I mean? Yeah. We both significantly changed. You know what I'm saying? So I wrote it in the window. My only complaint is what took you so long? The guy. What took you so long? I don't want to admit. I don't want to admit.
Thank you so much.
I want to show you.
Representative Markle, you're going to open the bill? No, okay, Markle's there, okay. Good afternoon. Okay, we're going to start HB 1522. Representative Markle, good to see you. Whenever you're ready.
Okay, thank you. Okay, thank you. First of all, thank you, Mr. Chairman, and thank you, members of the committee, for allowing me to testify today. My name is Jay Markell. I am one of the two state reps from Rockingham County District 18, that's Atkinson. I'm also a practicing attorney, and I have a practice which concentrates in family law, criminal law, and also general civil litigation. Before you today is House Bill 1522. The idea here is to amend and update the domestic violence statute. And the reason why it needs to be done is because I think that domestic violence, as we unfortunately saw in the middle of last year with the horrendous murder-suicide of Marisol Fuentes and her husband when he turned a shotgun on her and then on himself. It brought to the fore some things that have been going on, and we'd like to address them, I think, with this statute. First, I think it's important that we look at the scope of the problem in terms of domestic violence. As you might know, that's RSA 173B, which is the statute. The scope of the problem is that
In 2025, and this is the most, obviously the last year for which we have records, there were a total of 3,281 domestic violence petitions filed in the Family Division, which has jurisdiction over domestic violence petitions. Of that number, 2,704 were granted on a temporary basis and 573 were denied. Therefore, approximately 82% were granted and about 18% were denied out of hand. In your handout, you will see two exhibits to give you an idea of the size and scope of the problem beyond my letter of written testimony to the committee. In Exhibit 1, you will see the domestic violence stalking petitions that were filed and granted or denied in the Family Division for the entire last year. That's where these numbers come from. Now, there seems to be a slight discrepancy because that's the latest number filed, but when you look at Exhibit 2, which deals with the total amount of cases of varying types filed in the Family Division, you can get an idea of exactly how serious the problem is. It's so serious, it's to the point where that that domestic violence petitions as a category are the second largest single form of action that's filed in the Family Division. So we are talking an exceedingly serious problem. Anecdotally, I'm aware that approximately 1/2 the murders that take place in the United States are domestic violence related. So this is an exceedingly serious problem. What we're doing in House Bill 1522 is a couple of things. Number one, if you look at the bill, you will see that there are basically two elements in the present statute that somebody must prove. And number one, they must prove the existence of one of approximately 8 predicate criminal offenses. And number two, and most importantly, the plaintiff in a particular action must show that the defendant represents a present credible threat to the physical safety of the plaintiff. So what we're looking at, if you look at the statute as it presently exists, you'll see the things that the statute presently contains. They're easy to recognize: assault, reckless conduct, criminal threatening, sexual assault, interference with freedom. And that includes things like false imprisonment, somebody saying, "You're not leaving, you're staying right here," or holding you down or keeping you there. These things are very characteristic of domestic violence abusers and control. We look at destruction of property, unauthorized entry, harassment, cruelty to animals, and now what we're suggesting that we add is revenge porn. The reason why I think so is because this shows it's basically non-consensual dissemination of private sexual images as defined in RSA 644A. That is Exhibit 3, so that you can take a look at it, and that's exactly where it comes from in the statutes. It's an intrusion on privacy. So it certainly makes sense to include that. So moving on from there, what is coercive control? It's a pattern of conduct which is manifest in a number of different ways, which is designed basically to remove the personal autonomy and degree of control that an abuser will exert over an abused person. And we've got some information here for you. The causal relationship, and basically it's coercive control deals with things which, as we're putting in the statute, which is, I think, accurate, includes but not limited to isolation of a plaintiff from friends or relatives or other sources of support, depriving a plaintiff of basic needs, controlling or regulating or monitoring a plaintiff's activities, communications, movements, finances, economic resources, access to services, and through either physical or technological means. It's compelling a plaintiff to engage in specific conduct, which may include criminal conduct, or any single act which is designed to accomplish the above, which is aimed at a child, relative, or animal belonging to the plaintiff. Now, coercive control, to make sure that we're bridging the gap appropriately, is pretty well understood. We've got some handouts for you in your packet. In coercive control, for example, by Evan Stark, PhD, research shows that approximately 60 to 80% of female abuse survivors experienced coercive control, as well as physical violence and the emotional abuse associated with it. The Domestic Violence Society in Canada found that over 95% of domestic violence victims experience it. And it's also important to note that these acts, while abusive, are not in and of themselves criminal acts. There have been some attempts to criminalize this kind of conduct, but with very limited success. And frankly, we're not going in that direction, and at this point in time, don't contemplate it. And as you look into the research that's offered here to support it, jurisdictions that have currently used it are Washington State, which the statute is cited in your handout. That's been effective in July of 2022. And this writer notes that Massachusetts has adopted this effective September of 2024. Other states that have picked it up are places like Maine and a number of other states. Kentucky, New York are either working on it, and it's something which is getting more and more play in the United States and is being added to statutes. And importantly, when you look at coercive control, it also helps the trier of fact decide whether or not to grant a restraining order, in addition to the criminal effects, in addition to the criminal predicates that exist. So it reduces the likelihood of she said, he said, or he said, he said, or she said, she said, in any particular given situation. Also, it tends to be either document or text or device-driven type of case. So if you're being monitored by somebody unwarrantedly placing a GPS in your car without license, privilege, or authority to do so, you're going to have a GPS. If it's text-driven in the form of threatening emails, manipulation, or control, this is going to be there, likely, and it's going to aid a finder of fact to be able to determine whether or not this leads the level of abuse. Now, the interesting thing here is that there's no one emphasis on any particular aspect of coercive control that needs to be given any particular weight. So courts would be free to place whatever particular weight on any particular aspect of it to help them determine whether or not the defendant presents a credible threat to the safety of the plaintiff. So this is kind of where it's going. So this, at the same time, provides more due process in a way because they can be argued both ways. Neither party is painted into a corner. If, for example, somebody were to say, she is depriving me of basic needs, okay, the response could very well be, she is a spender, and I'm simply in control of the finances, and this is the way it's always been. So in other words, as they always are, these cases are evident and fact-driven. But what they do is they give plaintiffs who are mostly pro se and defendants in these types of cases who are mostly pro se better avenues to be able to plead and defend their cases. And at the same time, what they do is that they are able to bridge the gap between the predicate offense, the nature of abuse, the controlling aspects of coercive control, and be able to help make the bridge go across as to whether or not the defendant represents a present credible threat to the physical safety of the plaintiff. So this is why it's very important. The other thing is that this is as a concept is well understood in the judiciary, although it is up to us as legislators to be able to add this to the statute. It's also recognized around the world. A couple of things without taking too much time is I'm going to ask you to take a look at Exhibit 4, which is a guide to coercive control. I put it in your handout. It describes these things in detail and talks about the tactics people use. And then if you look at Exhibit 5, which is also in your handout, it's entitled, How Coercive Control is Expanding Domestic Abuse and Laws in Several States. So, and I note that this is talked about, even if you go online, you're going to see in Australia, this is talked about. We need to add this to our statute. In addition to which, I note that it's in coercive control, it seems to be the absence, and this is truly disturbing, of drug or alcohol-fueled behavior. So I'm suggesting that this is more probative of a characterological problem. And so, in other words, it's one thing to have assaultive offenses because somebody has a drug or alcohol problem that's capable of remedy. It's another thing altogether to be engaging in this kind of conduct when you don't have drug or alcohol dependence necessarily as a predictive factor as to how this is going to be manifested. And in particular, we're not talking about single incidences here of isolated conduct. We're talking about a pattern. So what I'm looking at here and what I'm suggesting is that this is going to be an aid, and I think this will save some lives. I can also tell you as a practicing attorney, last year, I can tell you that in Massachusetts, I was able to represent a victim, okay, of this particular kind of conduct. We were able to secure the order for her and of an order of protection, which is enforced to this day. And it completely and accurately described, okay, virtually everything that that woman was going through. That particular person also refused to turn over guns to the police, lied to the police, and hid them. And he may be currently facing gun charges in Massachusetts as well. So what I'm suggesting here is that we pass this bill. It got 13-0, absolutely no dissent to it in the Criminal Justice Committee. It passed on voice vote. I'm going to also include, as I have in here, an article. If you look at Exhibit 6, I have in there an article I did for the New Hampshire Bar News, which came out last November, in which I explain a little bit about coercive control and how it really needs to be handled and brought into law. For those of you who follow the New Hampshire Bar, every November, they print a family law edition. And so this may be something to consider in the totality of it. So I think in conclusion, I think we need to pass this law. I think it has big support. I think it's going to make life safer for a lot of people. And it may prevent the kind of tragedies that we saw earlier this year. It may also save a few lives and some serious physical injury in the process. So I thank you, and if there's any questions, I'm happy to answer them.
Thank you. No? Okay, Senator Osho.
Thank you, Mr. Chair, and thank you, Representative. What a comprehensive packet. And if only all legislation were to come forward with all the supporting documents, this is great. Thank you. I have some reservations, and I'm hoping you can talk me through it about adding coercive control to the list. In that it could be, someone who is using coercive control is most often controlling the entire situation, controlling the relationship, controlling movement and finances and all of that. And is there any concern that they would also use this preemptively? So, say for instance, a couple have location tracking on their phones. They know where each other are. And the abusive partner turns off his and then asserts that his partner, who they are controlling, is actually controlling them. And look, they're tracking my every movement and I can't go anywhere without them knowing, and I don't have the same access to their location, just as an example. Is there any concern that it would be used preemptively against the survivor
That's a
by
good
the
question.
perpetrator?
Yeah, that's a very astute question, and thank you for bringing it. People like this tend to be highly manipulative, and
Yes.
they can certainly put spin on a case, which we recognize.
Yes.
But courts, one of the things that courts are required to do is shrewdly observe what is going on in court. In fact, it's a charge from the New Hampshire Supreme Court that courts are supposed to see through the machinations. They're supposed to see through the representations made by lawyers, see through the pleadings and get to the real nub of the case. And so while somebody tries to manipulate something and make it look like something it's not, courts are charged with that, number one. Number two is that, and I think this is equally important, is that it's a case that's going to be measured in the totality of the circumstances. So, and this is why I said we talked about basic financial needs. So somebody could conceivably say, she put a GPS in my car, okay? Now, there may be perfectly innocent reasons for it. However, we have to remember this. There are now 8, or will be 8 predicate criminal offenses that have to occur before a petition would be granted. So in other words, you're going to need to have assault, false imprisonment, and the variety of other the predicate criminal offenses. So in other words, you just can't walk into court and say coercive control and not have any of the predicates. So this supplements the pleadings. It doesn't drive the pleadings.
Oh. Andrew.
Thank you. And thank you for taking my question. And
Sure.
I also thank you for the packet of information here. So I'll say the data of the number of cases, and I've worked in the domestic violence area before, is just blows me away that how pervasive this is. And my question is, did you collaborate with the Bar Association section or the coalition on this bill? Are these the words they were looking for?
Actually, no, I didn't. What I did was I did my own research. I guess sometimes I tend to be a little bit of a loner. I've also done dozens of domestic violence cases in both Massachusetts and New Hampshire over the last 25 years. Dozens, maybe more than dozens. There are certain patterns that recur. I did hear from other people who independently thought this might be a good idea, but I was certainly open to work with anyone who was willing to do it.
Thank you.
Thank you very much.
Thank you, sir.
Rep. Lori Corson. You get 2 minutes here, so
Thank you, Chair.
let's see how you do. No, you can have more.
Members of the
But you
committee.
did put 2.
For the record, my name is Lori Corzin. I represent Coas County, District 7. Berlin is actually one of my cities that I represent, and I knew Marisol personally. Her and her little brother would always sneak my grandson some flan when we went in there, and she was someone who touched our whole community. We miss her today. Our community is still devastated. But today I stand before you to speak for those who cannot speak for themselves, one of those voices being Marisol Fuentes. Marisol was 25 years old when she was murdered in Berlin by her husband, but the killing did not begin that morning. It began years earlier with isolation. He cut her off from family and friends. He controlled her movements, her communication, her finances. He monitored her every action using GPS. He threatened those she loved, By the time Marisol reached out for help, she had been living in a prison built not of bars, but of fear, manipulation, and control. Our systems failed Marisol because it didn't fully recognize what was happening to her. It saw individual incidents, but missed the giant pattern. It saw behavior that looked controlling, but lacked the legal framework to call it what it was: coercive control. Coercive control is already in law in 10 other states, and other states are looking at it right now. This bill gives the courts that framework. It amends RSA 173B:1 to recognize that abuse isn't always physical, that a pattern of conduct designed to threaten, intimidate, isolate, and control is itself a credible threat to safety. Marisol did everything we tell victims to do. She reported, she sought protection, but the law hadn't caught up with the reality of her experience. We cannot bring her back, but we can honor her by ensuring that the next woman who walks into a courtroom will be heard, believed, and protected. I sincerely urge you to vote ought to pass, and I will answer any questions.
Thank you very much, Representative. Seeing no questions. Thank you.
Thank you.
Representative D. Simone. We're falling around each other. Committee
Yes,
to
we
committee.
are, aren't we? Thank you, Mr. Chairman and members of the committee. I come before you today with a heavy heart. One of the three loves of my life, my youngest child, is the person that Representative who introduced the bill spoke of. I noticed things that were happening between her and her spouse. Like a dutiful mother, I kept my mouth shut in front of him and would say to her, "Are you truly happy, sweetheart?" And she'd say, "I have to think about the children, Mom." I was babysitting one night and she came home from the party and came in the house by herself. And she cowered in the corner. I said, "What's wrong?" She said, "Mama, please don't let him in." After a while, she went to bed and she said, "I'm going to lock my door, Mom. You can let him in." I did, and he proceeded for the next hour to tell me what a horrifying person she was. This is a young woman who is a pediatric nurse, has the kindest heart in the entire world, takes care of her mom and dad when we needed it, adores her children, but according to him, that's not so. Finally, about a year and a half ago, she called me on the phone and she was hysterical. She said, "Mom, I need you. You have to save me." She found what was referred to earlier as a GPS in her car. She said, "Mom, where did this come from?" I said, "Who knows, sweetheart?" Called the police and they said, "File a report." She did. Shortly after that, she found out that he had gone through her phone when she was asleep at night, took pictures out of context. She and I had been out for dinner. She had one glass of wine. I know, I was with her. We had pictures. We were joking around, having a great time. He took that picture, showed it to his 8-year-old child, and said, "This is your mother, the effing drunk. I'm going to take you away from her because she's no effing good." The child was in a fetal position begging, "Stop, please stop." She heard it, came downstairs, took a video of it and said, "You need to stop from going to the police." And he said, and I quote him, "It's on the video." Go ahead. I never laid a hand on you or her. Who do you think they're gonna believe? Then the final day came. This went on and on and on and on and on. The final day came when she called and said, "I can't do this anymore, Mom. I have to save my children." He held her hostage in the house, in the bathroom, for hours, screaming at her, telling her that he was taking the children from her, telling her she was whatever, whatever, whatever. He wouldn't let her out of the bathroom for a very long period of time, and then he moved away to cough. He went like this, and she snuck by him. This person weighs 280 pounds. She weighs 110. I say that to you because when she got out of the room, she grabbed her escape bag that I made her make. The children were in school. She tried to get down the stairs. He jumped in front of her. She has the video, and he said, "Oh my goodness, you just threw me down the stairs. I'm going to the police." She escaped the house, called me, and I said, "That's it, baby, we're going to the police. You have to stop. He's escalating. You are going to get hurt." That was the day he lied to the police and told them 4 times that he did not own any weapons, but he did. 500 rounds of ammunition that he had hidden. 500 rounds. I'm a gun owner. I've owned guns all my life. I've never had that much ammunition for one handgun. So we knew he had more. The police had to ping his phone to find him, to serve him with the restraining order. She said, "But Mom, I don't know if I can get a restraining order. He didn't hit me. I don't have broken bones. I don't have black and blues." I said, "Honey, you wait long enough. You're not going to have those either. He's going to kill you, like they did Marisol. He's going to kill you." He verbalized that statement to 2 other people, that she would not get 1 dime from him. Quote, he even said it to the judge, "I'm not giving her 1 dime. And the judge said, "Sir, this is for child support." And he said, "I don't care. She's not getting it." Well, she is getting it because the judge ordered it. But the point is, Marisol would be alive today had New Hampshire had this law. Do we wait continually till women are beaten and murdered before we stop these people? These people are out of control. Men have learned, women have learned, as long as I don't lay a hand on him or her, I'm good to go. A judge said to me 2 years ago, I say to people all the time, "Sticks and stones may break your bones, but words can feel like a punch in the face." That's what these people who are verbally coercing their spouses to do what they want them to do, that's what they do. With their words, they punch them in the face. And then someday they come home with that gun that they have hidden and they murder them. My daughter is free of him. Currently, her restraining order is only good until June. We're still going back and forth to court. The point is, right now, she is safe. We don't know what's going to happen in the future. I live in fear every single day that my grandchildren or she are going to be killed by this man. I don't want Marisol to go unnoticed. I don't want that poor woman's death to go unnoticed. I would like to see this bill named the Marisol Pauline bill, because my daughter got brave. and she's not there anymore, and he can't beat her anymore with his mouth. Her children can't be beaten by him with his mouth anymore. I don't want it to happen to one more human being what happened to Marisol. We in this state are smarter than that. We are just smarter than that. I apologize for the emotion, but that's what this is. It's frightening. I will take questions.
Thank you very much, Representative. We appreciate your coming here today with a hard testimony to give. So we appreciate it. We feel for you. Thank you. I don't think we have any questions. Appreciate your coming though.
Thank you.
Mary Krieger. Hi, Mary. How you doing?
Hi, good afternoon, Mr. Chair and members of the committee. My name is Mary Kruger. I'm an attorney at New Hampshire Legal Assistance. We are a statewide nonprofit civil legal services law firm providing free representation for qualifying clients, low-income clients, and aging clients in New Hampshire, in a wide variety of civil cases designed to help people meet their basic needs like housing, food, healthcare, and safety. We operate a domestic violence advocacy project. I am supervising attorney for that project and have been doing this for close to 20 years. Last year, NHLA represented 209 people in our domestic violence advocacy project in final protection order hearings, which is under RSA 173B, which is the statute that this bill would address, and in high lethality divorce and parenting cases. All the clients we represent in both of those types of cases are screened in as high lethality cases, so the kinds of cases where the domestic violence could lead to serious bodily injury or death. We do support the addition of coercive control to RSA 173B. We also support adding the non-consensual dissemination of private sexual images as defined in RSA 644-9A. I wanted to just point out that one concern that we do have as the way that it's currently written is potential misuse. So we do share that concern that was raised earlier, where abusers could potentially allege coercive control as an act of abuse and successfully be able to obtain a domestic violence protection order against the victim. That is a way that this does get misused. And in order to counteract that, we would be open to working with the sponsors of this bill to potentially look at making a change where coercive control could be part of a definition of credible present threat to safety. And so when someone goes to court to obtain a domestic violence protection order, they need to prove two things: that there's been one or more of the enumerated acts, which are you can see in the bill draft. Those are all acts that are defined through our criminal code, and a person would just have to demonstrate either the commission of one or more of those acts or the attempted commission of one or more of those acts in order to demonstrate that there is an act. And then that person would need to demonstrate to the court that the defendant poses a credible present threat to the safety of the victim. And we have many cases that have interpreted what that means. And in New Hampshire, our court has really looked at credible present threat to physical safety. So adding a definition of credible present threat could help courts to determine the kinds of behaviors that might constitute a credible present threat to physical safety, and or expand the definition by utilization of this coercive control definition that is a pretty good definition in this proposal here. And that would help to demonstrate that that kind of behavior can indicate that someone is a credible present threat to safety. So that would be one way to address this. And it's not to be difficult and sound like we would be like against having this, because this is something we have talked about for years within the advocacy community. Really, how can we get at that piece that we know is present in these cases? We see it all the time, and it is extremely dangerous behavior that we see. But in addition to the concern over misuse of this, broad definition, which is important for it to be broad, and courts ought to apply the statute broadly generally, could raise some constitutional issues if it's in the section where it would be considered an act of abuse. And not to get too technical, but there has been there's been U.S. Supreme Court decisions about when the court looks to make relief under one of these kinds of laws, including relinquishment of firearms and potential restraints on speech, that can be challenged if there's not a requisite mens rea that is in the definition of an act. So currently we have all of the definitions following the criminal code, which all are crimes listed there, and the addition of the non-consensual dissemination is also a crime, and all of those have the requisite mens rea. That could be vulnerable to constitutional challenges, which it was a conviction under a stalking law was overturned because of a constitutional problem, because that state's stalking law did not have a mens rea. Our state does. So we have purposely, knowingly, or recklessly. Those are the sort of requirements in order to put any restrictions on someone's speech for having stalked someone, or to find that someone's verbal actions could be considered unlawful. And that was the Counterman case in 2023. And our court also found that it was okay to restrict certain speech under the stalking law because we did have that mens rea in there. So, so I just am, again, not wanting to create a law that then a victim could obtain a protection order and then have it challenged successfully, potentially overturned, and that could affect many victims who maybe have obtained protection orders, and it just could wreak some havoc that way. So I wanted to just point that out and just encourage the committee to consider that this may be open for an amendment, and we'd be more than happy to work, meaning NHLA, with the bill sponsors on making some of those changes. Thank you.
Questions? Thank you for your testimony.
Thank you.
Lynn Cholette.
Good afternoon, Mr. Chairman, members of the committee. My name is Lynn Cholette. I'm the Executive Director at the New Hampshire Coalition Against Domestic and Sexual Violence. And in the interest of time, I'm thinking I can probably pull together several of the statements you've already heard prior to this. We are here in full support of House Bill 1522, and we truly appreciate the sponsor's interest in looking at the very nuanced ways that victims experience domestic violence. We also support a conversation about an amendment, as the prior witnesses have mentioned today. So as you've heard, the first thing the bill does is add the dissemination of non-consensual sexual images to 173B. That is a very good idea because the dissemination of these images is often used to threaten, intimidate, or harass a victim. And whether those images are real or not, they have the same profound, distressing effect on victims. So let's move to the bigger picture question of coercive control. The coalition has been engaged in active discussions about adding this concept to our state statutes for many years. We've engaged in conversations with prosecutors, with civil attorneys, advocates, the judicial branch, and also our sister coalitions in other states. While the term is defined a little bit differently in different contexts, it is widely understood to be a pattern of behavior in intimate partner relationships that are threatening, intimidating, harassing, and ultimately have the impact of controlling a victim's behavior by isolating them and removing them from support systems and resources that they need. The reason it's important to be adding this now to our statute is to help ensure that the full range of dynamics of domestic violence are at the court's fingertips when they make a decision. And I think you've heard some really powerful examples of that today. When we look around at what's happened in other parts of the country already, 9 states have already added coercive control specifically to their statutes. 9 more states have added very similar language. And there are 2 states, including New Hampshire, that already have pretty similar language. For us, that's our harassment crime. You heard a reference to Massachusetts adopting a new statute in 2024. Connecticut and Maine have as well. So when we look regionally, other states are doing something very similar. We do recommend considering an amendment specifically to get to the issues that Senator Altschiller raised in her comments this morning or this afternoon. We encourage input from the judicial branch right now as well to ensure that there are not unintended consequences when this language is added to the bill. And that is really exactly what the questions got to earlier today. And we appreciate the work that New Hampshire Legal Assistance has done, and we would very much like to partner with them and the other stakeholders in working on that amendment to ensure that it is not inadvertently used against victims when an offender tries to use the language to intimidate or track a victim. So what we know from working with victims every day is that we're watching that the case law has shifted over time in terms of the interpretation of this statute outside of the intent of the legislature. And we believe that putting this language of coercive control back into the law will give victims meaningful relief. So thank you for the opportunity to testify. And we are very interested in working with the other stakeholders on an amendment and appreciate all the support behind the bill.
Question for you. Under the coercive control part, does the word intent not cover knowingly and purposefully?
I am going to defer back to Mary Kruger on that because she's really the expert on the case law interpretation on that.
Thank you. Other questions?
Thank you, Senator. Okay, thank you all very much.
Thank you. Does anyone else wish to testify on 1522? Seeing none, that'll end the hearing. Brendan, maybe remember you were keeping me to a smaller amount of bills? I thought we could fly through them. No. Not as quick as I thought. I'm at that flash age, you never know. Protection relative to sexual assault. Representative Rhodes, there you are down back. Come on up. Introduce 1651 for me if you would. How you been?
Am I the next contestant in the
On the
road
prices.
of
judicial.
judiciary?
Yes, thank you.
Thank you, Mr. Chairman, members of the committee. And if I may, Mr. Chairman, just give a quick thank you last week for allowing my friend Senator Abbas to introduce a bill for me that I was not able to be here. And I appreciate you giving it the time that it deserved otherwise. However, I am here today to introduce House Bill 1651. And like many of the bills that I have before you, they have to do with strengthening bills surrounding the victims of sexual assault. Because a victim does not have to report the crime that has been committed against them until they are ready, if ever. Generally, or a lot of times, especially with sexual assault, because we're not talking about domestic violence in this particular situation, you very well may not have a relationship with that person at all. The last thing you would want to do is pretend like you did have a relationship. So this particular bill is going to give a person that has been the victim of a sexual assault the same protections that a person who is in a relationship would otherwise be entitled to. It's basically going to extend over into the civil world, and it would have the same requirements that have to be met just like in a domestic violence situation. Additionally, last year, and I believe it was Senator Altshuler's bill, that it allowed for a specific timeline for a person's kit to proceed through the process. So what we've done also in House Bill 1651 is just ensure that a victim is able to receive the update of exactly where their case is in that line of procession, for lack of a better word. Additionally, we are enhancing the Victim's Bill of Rights to make sure that a person's evidence is not destroyed prior to their statute of limitations being up. As you know, depending on the age of the victim, you have, different criteria as for what the statute of limitations are. And there was a federal law that was changed, and we just want to make sure that if a person was a minor, that their evidence is not destroyed. I believe would be like up until the age of 40, if I'm not mistaken, depending on the age, because you have, 20 years past that. And let me see what else we did here. Well, that was a lot in about 30 seconds time, but I think I covered the gist of exactly what it does. It's just 3 pages of it.
Thank you very much. Any questions? Seeing none, thank you for your testimony today.
Thank you very much.
Mary Cregan, I think you're still here. Why don't we bring you back up? You were a wealth of knowledge, so share. Good afternoon.
Good afternoon, Mr. Chair, members of the committee. Thank you for taking my testimony. My name is Mary Kruger. I'm an attorney at New Hampshire Legal Assistance. Providing civil legal services to low-income clients for free in cases involving their basic needs such as food, shelter, healthcare, and safety. We operate a domestic violence advocacy project, and I'm a supervising attorney on that project. We are here in support of HB 1651. This is a long time coming, in my opinion. We do have a huge gap in our system for protection orders for sexual assault survivors specifically. Under the domestic violence law, RSA 173B, the person can access protection under that law if they are a sexual assault survivor, but only if they have what's considered a qualifying relationship where they're either a dating partner, married, cohabitating, or related by blood to the defendant. Otherwise, they cannot access protection under that law. We also have a stalking law.
where you don't need that qualifying relationship in order to access a stalking protection order in the civil context. However, you need to show a course of conduct, which is one or more acts of stalking behavior. Sexual assault may only be one act, and it may not really fit into the definition of stalking. And so for those sexual assault victims who don't have the qualifying relationship, or there isn't the stalking behavior, their only remedy is to go to the Superior Court and basically get injunctive relief, which is not the same. If this is adopted, HB 1651 would provide for that person to have essentially the ability to go to the circuit court, as a domestic violence survivor could do today, and apply through a petition process for a sexual assault protection order. And it would follow all of the same procedures, burdens of proof, methods of notice, service, enforcement, and penalties of violation as those that are currently under RSA 173B, which is the Domestic Violence Protection Order. Our stalking law basically follows that same process. So we would just be adding sexual assault to that, and the courts already know how to do these cases. So they would just be having to demonstrate that the sexual assault under the law, under the criminal law, had occurred based on a preponderance of the evidence. And this would allow for that gap to be filled. And we think that that's a really important thing for New Hampshire to do. So we're asking you to pass this, and thank you very much.
Thank you. See any questions? Senator Alshaw.
Thank you. Thank you for taking my question. I know that one of the things the courts will often order for a perpetrator is batterer's intervention. And is it necessary to keep that in there? Because it doesn't really exist here in the state of New Hampshire. It's mostly online. Is that a problem that you see for this bill at all?
For this particular bill, I don't see that as a problem. I see it as a problem that we don't have better intervention programs that follow the sort of protocol for those programs available in New Hampshire, as we once did. But I think that's a separate issue. I don't think it is problematic for this bill specifically. But this bill would allow for a court to order any of the relief that's available under RSA 173B, including that, but many other things that would be helpful for survivors. Yep.
Thank you very much for your testimony.
Thank you.
Lynn Gillette. Long time no see.
Long time no see. Good afternoon again, Mr. Chairman, members of the committee. For the record, my name is Lynn Gillette. I'm the Executive Director of the New Hampshire Coalition Against Domestic and Sexual Violence. We are the umbrella organization for 12 community-based crisis centers that provide free and confidential services to approximately 13,000 survivors a year. I am here to speak with enthusiastic support for House Bill 1651, and I'm joined today by Shauna Foster, who's the Executive Director of New Beginnings in Belknap County, and Shauna will speak after I do. As you heard from the sponsor, the bill does two important things. It creates two amendments to the Sexual Assault Survivors Bill of Rights and creates critical updates to the protective order laws in New Hampshire. So New Hampshire has long recognized the need to fill in the gap for those sexual assault victims who do not currently have a legal remedy, as you heard from Mary Kruger today. This gap has been recognized around the country for decades. In fact, over 20 years ago, I led the effort to create the first standalone sexual assault protective order in the country in Illinois. Today, there are 23 states that have specific sexual assault protective orders and an additional 14 states that include sexual assault in their current statutes. The kinds of circumstances where this is necessary are incredibly common. College classmates who eat in the same dining hall, live in the same dorm, I worked with a survivor who was sexually assaulted by a work colleague at a conference. And when they went back to work in their offices, he would just stop by her desk regularly, which to everyone else looked like innocuous behavior. It was terrifying to her because he had sexually assaulted her at the conference. Neighbors, or anyone who is raped and needs the offender to stay away from them. So the beauty of this bill is really its simplicity. As you heard, there are already processes in place for these orders. We also are in full support of the 2 amendments to the Sexual Assault Survivors Bill of Rights. We certainly want to ensure that evidence collection kits are retained as long as the criminal statute of limitations. And the last provision ensures that victims are notified of the status of their kits. What we know for rape victims is that one of the greatest losses they experience is the loss of control over information about themselves and their bodies, and letting them know where that evidence is a very important step in helping them regain that control. So I'm happy to take questions and also to turn it over to my colleague, Shauna Foster.
Good afternoon. My name is Shauna Foster, and I'm the Executive Director of New Beginnings Without Violence and Abuse. We are the Domestic and Sexual Violence Crisis Center based in Laconia and serving Belknap County. I'm here today in strong support of House Bill 1651. As someone who's worked with sexual assault victims for well over a decade, I'm excited to have the opportunity to provide information about how this bill will improve protections for sexual assault survivors in New Hampshire. In 2025, New Beginnings advocates provided 529 services to 108 survivors of sexual assault, including safety planning, financial assistance, 14 hospital accompaniments, 60 accompaniments to forensic interviews, 12 court accompaniments, 4 law enforcement accompaniments, and financial assistance, which included relocation assistance. And again, this is in Belknap County alone. Victims of sexual assault have a variety of resources available to them. However, unlike victims of domestic violence and stalking, sexual assault victims often don't qualify for a civil protection order, which is why this bill is so important. And in those instances of relocation assistance that I mentioned, had additional relief been available through something like a protective order, those victims may have chosen to stay in their housing and in their communities rather than relocate. I'd like to share 2 recent examples of cases where a survivor working with a New Beginnings advocate was unable to obtain an order of protection, even though it would have greatly enhanced their safety. One survivor presented at the hospital for a forensic exam after being sexually assaulted by her coworker. She was fearful of retaliation and continued abuse by the perpetrator, and she expressed wanting relief from the court to help her move forward. However, her order was denied due to the nature of her relationship with the person who harmed her. Another survivor experiencing homelessness was sexually assaulted by another unhoused person. They had no relationship outside of the assault, and the offender had not engaged in any patterns of behavior that would have met the criteria for a stalking order. The offender knew where the survivor stayed at night and the places that she frequented during the day. The perpetrator fled to an unknown location after the survivor reported her assault to law enforcement. She felt very unsafe, vulnerable, and did not qualify for an order of protection through the court. Protective orders for sexual assault survivors are critical because they help keep survivors safe, prevent ongoing contact and retaliation, and provide legal relief for the survivor. They also give law enforcement a clear path to intervene in cases where there's repeated contact or abuse from the perpetrator following a sexual assault. Thank you for your consideration. I'd be happy to answer any questions that you have.
Thank you. Seeing none? Thank you.
Thank you.
Appreciate it. Pat Sullivan.
Good afternoon, and in light of all of the previous testimony, I'll try to keep it short and have submitted written testimony as well. My name is Patrick Sullivan. I'm retired chief from Goffstown. I'm also the executive director of New Hampshire Association of Chiefs of Police. I'm here to testify in support of House Bill 1651 that establishes sexual assault orders of protection relative to the sexual assault survivors' rights. I've worked in law enforcement for over 40 years. And I believe that the current protection orders are lacking when protecting those people that need some of the best protection that we should be giving them. I think that by passing House Bill 651, this body can ensure that protection is based on the victim's need for safety rather than the offender's relationship to the victim. And I'll leave that there, and I've submitted my written testimony. Welcome any questions.
Thank you very much, Chief. I think we're all set. Thank you.
Thank you.
Stephen Andres.
Good afternoon, Chairman, members of the committee. My name is Stephen Enders. I'm an attorney in Concord who practices criminal law. I've been doing so for about 25 years. I am in support of House Bill 1651. As prior speakers have said, there is a process for any person to try and obtain a protective order in Superior Court. However, that process is not necessarily user-friendly. It requires both a filing fee as well as going to Superior Court, and Superior Court tends not to be a very quick process. As Attorney Kruger had indicated, we've streamlined that process in New Hampshire for certain vulnerable populations, victims of domestic violence and victims of stalking. We have laws in place where they can travel to a circuit court and obtain relief for free in a much more streamlined, quicker process. This allows victims of sexual assault to utilize a similar streamlined process, go to circuit court, and for free obtain a protective order against a person who's committed a sexual assault against them. What's nice about this is it's completely separate from the criminal justice system, so you wouldn't necessarily have to report this to the police. If you felt it was appropriate, you could go get a protective order. This also amends the statute of limitations in a very logical way. The current statute requires sexual assault evidence kits to be preserved for a period of 20 years or the statute of limitations, and it says whichever is shorter. And that doesn't necessarily make sense because the statute of limitations for a sexual assault is 22 years after the victim's 18th birthday. So it would make sense to change that you have to preserve it for the statute of limitations or 20 years, whichever is longer. This bill does both of those things, and I'm also happy to answer any questions you may have.
Thank you very much. I think we're all set.
Thank you.
Have a good day. Does anyone else wish to testify on 1651? Seeing none, that'll end the hearing. Representative Love, how you doing?
Good afternoon, Mr. Chairman and members of the committee. For the record, my name is Representative David Love. I represent Rockingham 13, which is the town of Derry. And I serve on the Children and Family Law Committee. I also served on a committee a couple of years ago to investigate DCYF. And after hearing story after story after story of children being beaten and nothing being done, whether it, a punch in the head, a kick in the back, these are not disciplinary things, that I understand that, a lot of people want to be able to, slap the kid on the butt. But, when you close a fist, there's a difference here. And when I was on that committee to investigate DCYF, I heard all kinds of stories, and it came to my, I just had the thought that, if I hopped over this desk, Mr. Chair, and I ran up and I punched you in the head, there'd be a whole bunch of witnesses here. The police had come, they'd question the witnesses. I'd be dragged out of here in cuffs. I'd have to post bail. I'd have to go to court, get a lawyer, and what have you. But if you're my 5-year-old son and I did it at home, chances are I'm going to get away with it. And that's the purpose of this bill. We had, the Harmony Montgomery thing, and, I heard all too often that, she just slipped through the cracks. Back in 2022, I think it was, there was a report out from WMUR about 19 deaths in 11 months of children. And Senator Carson was quoted in it, and she mentioned that slipping through the cracks thing. We've got an opportunity to clog up a couple cracks with this bill. DCYF, when it was first formed, was supposed to be a social service agency. If your family was in trouble, financially, or you had a troubled kid, or to find ways to help you. And somewhere along the line, they turned into the law enforcement arm of the family court, and they're not trained for it. I get a hold of John Sipper, the trainer at the State Police Training Academy, and I asked him if DCYF ever sent anybody over there for investigative training. He said no. Okay, we've got a good training program here in New Hampshire, and it's not utilized by DCYF. And another thing, I'd like to point out, these kids come out of college with a social services degree, and they're 22, 23 years old. Then they have to go talk to somebody like Adam Montgomery. And I know that wasn't the case here, but there are many people like that in the state. And, they get scared. Adam Montgomery is, another case that, talk about cracks. The Dimitri Sepsis or Sepsos, or whatever, however you pronounce his last name, never should have been working for DCYF. He had two instances where he was fired from jobs within the state for violence. He was, sexual harassment, and then he got arrested for assault and battery on his wife, and then we have him investigate violence against children. I can't see the sense in that. But anyway, we have good law enforcement here in the state, well trained, and we should use them. The kids deserve it. A 5-year-old or a 10-year-old shouldn't be getting punched, and it happens all too often. On that special committee to investigate DCYF, a man stood there and he said, "My child is being beaten by my ex. All they told me is there's no broken bones, there's no hospitalization, there isn't much we can do about it." Do you know I was told that 22 years ago when my daughter was being beaten? Okay, it's bad policy. It's got to be. If they're using the same word for word, let's have the police to investigate the crimes. It doesn't make any sense not to. And I'll take any questions.
Thank you for your testimony. Senator Ocean.
Thank you, Mr. Chair, and thank you for your testimony. Do you recall a few years ago, we passed legislation that corporal punishment could not be used on foster children, even if a foster parent used corporal punishment on their biological children, they could not.
I do recall.
You recall that? So this bill takes it a little step further from there, right? In that, does it specifically cut out the Department of Health, DCYF, from doing their minimal facts investigation? Or is it complementary? Like, how practically does this work? I'm like,
if there has
take me
been
along with
okay, sorry, I interrupted you. If there's a crime been committed, if somebody, if somebody punched a child, okay, it should be out of. DCYF is about, social services. It should be. That's what they're trained in. If I punch somebody, I've committed a crime, and that victim deserves the expertise of criminal investigators.
Oh, thank you. Thank you. I'm just going to say I agree with you. I'm with you there. I'm wondering, does this belong perhaps in child abuse statutes that, you know, we take that physical abuse of foster children and apply it to biological children as well. Would that bridge that gap? Because it now, you know, goes into criminal behavior? Just,
I do not want to, thanks for the question.
Yeah.
I don't want to take away a parent's right to slap a kid in the butt. I'm not talking beating, just let's get their attention type of butt, you know, butt slap. You know, and that can certainly be construed as abuse by some people. What I want is, you know, you close your fist on a child, you know, you've committed a serious act. And, you know, there's too much of that going on. And I hear it all the time. You know, when people find out I'm on the Children and Family Law Committee, boy, do I get stories. You know, and it's got to stop. And DCYF is not the right avenue to go down, rather the right vehicle to use to stop it. You know, we've got too many dead kids. We've got too many wounded kids. You know, that you talk to school teachers, and some of these kids come to school pretty bruised up, and nothing ends up happening. No broken bones, no hospitalization. There isn't much we're going to do. You know?
Thank you, Mr. Chairman. Thank you for taking my question. On page 1,
I don't have it with me.
line 4, it says,
thank you so much.
it says that it has to be immediately verbally reported to an on-duty officer. Is there a reason why it must be verbally? It can't be sent by, I don't know, fax, email, any other way? I mean, what's the rationale for it being verbally?
Line 4. I think that's the part that was amended. I'm not sure. But anyway, amend it if you want. There is one thing that needs to be amended in here, by the way, is the effective date. It's already gone by. So. But, you know, if you, by email, whatever, that's fine by me, you know?
My concern is, although verbally it can be done, it's sent, if it's either a written report or if it's by email or whatnot, it's evidence or shows that it's been done, because you're creating an obligation onto the department to do something, make a report. But there's no, I mean, I'm sure the officer would then document it, but I'm just wondering why, was there any discussion of that in the other chamber? Why it's verbally, or?
There was a little, because of the immediate, there was some discussion on that. There was a Child Protective Service officer from Newport, and I think I've got his name in here, but he said, you know, that there was a few things in there that bothered him, because we do have, you know, towns with police station closes at 4:30 in the afternoon, and nobody shows up till 7 in the morning. And, you know, I'd be okay with amending that part to fix that, you know, to maybe stretch it out 24 hours you have to, rather than immediate.
Well, just for clarification, I don't have any problem with the wording immediately. I'm just saying it's mandated as it's written that it be done verbally, which there's no problem keeping verbally in there, but does it have to be, is that the only way it can be done?
Oh, verbally or by email, whatever other way you, I imagine that's the way we do things nowadays is verbally or by email or text or whatever, you know.
Thank you.
You had mentioned earlier, 2-3 minutes ago, about if a child was at school and the teacher observed marks and bruises. Aren't they mandated reporters who have to report it anyways?
They are, but God only knows, you know, I know in cases I know of, it gets reported and no broken bones, no hospitalization, there isn't much we can do. You know, and they literally get sick of hearing from the same accusers, you know, or the same, put it this way, the same child, but different accusers, and is.
Okay, appreciate your testimony. We're all set. Thank you.
Thank you.
Did you have more? Okay, okay. Susan Larrabee. Good afternoon.
Good afternoon. My name is Susan Larrabee, and I am General Counsel and Legislative Liaison for the Department for the Division of Children, Youth, and Families. I think this is my first time before the actual Judiciary Committee, so I'm happy to meet you all. I've been following this bill in the original state as it was then retained in committee over the fall and then worked on with this amendment. And I do want to note that I know John Williams, our lead legislative liaison, did reach out to Kevin Ripple because it looks like the original fiscal note is still attached to the amended bill. And I do want to note that there is no fiscal impact as now written through this amendment because basically there really is no change of practice. And I really want to reiterate that because I know there has been some testimony that is a little bit confusing. This statute is from 1999, and we can't look at it in a vacuum because we have so many other statutes now addressing not only the reporting of suspicions of abuse and neglect, but how are these reports then, if they reflect a possible crime to a child, then reported to law enforcement, and then we begin a joint investigation, a parallel investigation through a multidisciplinary team. So I do want to reflect that this statute predates first joint investigations, right? The biggest change is having CACs, Child Advocacy Centers, and that was changed in the early 2000s, and that was codified in statute with, 169 C38A, which is now addressed in the amendment, that talks about the sharing of information through a multidisciplinary team, how those multidisciplinary teams are investigating and assessing allegations of abuse and neglect and putting forward a mandate for there to be protocols on those. And those protocols are what's called the Attorney General's Office, Division for Children, Youth, and Families, Granite State Children's Alliance, Model Protocol for the Multidisciplinary Response to Child Abuse and Neglect. And these are the protocols that we follow that guide our practice. Specifically, in the protocols themselves, each discipline has a chapter. How are we relating to the other disciplines? How are we notifying the other disciplines? Yes, we are orally reporting to the local law enforcement where the crime is alleged to have occurred because we are investigating a civil act, abuse and neglect of a child in the civil realm. Police are investigating the criminal aspect. Has this child been a victim of a crime? Those are two joint parallel investigations, but they're different. We're focusing on the safety of the child. Police are focusing on offender accountability. And then we all meet and basically work together on these at the Child Advocacy Center because that is best practices to have one forensic interviewer interview the child to address both the civil possible action of a petition of abuse and neglect and a possible criminal allegation of it being assault or sexual assault or endangering the welfare of a child or a myriad of criminal charges against that offender. So bottom line is the way we have amended this and worked on this in the committee over the fall was there really is no change of practice. And that's why the fiscal note has gone down to 0. It's just codifying what we are doing in the protocols as we continue to always work together with best practices of ensuring that everyone's needs are met, and first and foremost, that a child is safe in New Hampshire. And I'm happy to take any specific questions.
Sandra.
Yes, thank you, Mr. Chair. Thank you very much, Ms. Larrabee. Welcome to Judiciary.
Thank you. Thank you for having me.
So the multidisciplinary teams that are coordinated through the Child Advocacy Centers, this bill, as it's presented to us, you don't see any interruption of the team doing its work with on page 1, lines, the addition of lines 24, 25, and 26.
Correct, no.
Okay.
And again, that has always been there. Basically, we're orally notifying the police officer. We're following that up with what's called a law enforcement letter, which basically gives in writing what we've already told the police officer. We're meeting with the police officer and discussing next steps. And if there is a need to go to a school and interview a child, we're offering that to the police officer as well to come with us and do a joint interview there if that's necessary. And then the bottom line saying that law enforcement shall not rely on the department to gather information for its investigation unless such reliance is required or necessitated by the standardized protocol, and then references the protocol. So we are sharing information. So I don't think the way it's written prohibits that in terms of, again, it's one interview. Well, and best practices, it's one interview of the child, and we're sharing that. They're at the table as well during that interview.
May I follow up?
Yes, you may.
So just to be clear, none of this interrupts DCYF conducting a minimal facts interview?
Correct.
And none, may I follow up?
Yes, you may.
And none of this interrupts the process by which a child is interviewed by the Child Advocacy Center trained advocates, so that that child only has to experience one interview, not with law enforcement as
correct. There's
in
nothing
addition
in this
to a law
bill
enforcement
that
interview.
contradicts or is not in alignment with the best practices of the model protocols.
Okay, so the best practices of working with children who have been traumatized
Yes.
by the crimes outlined here, sexual abuse, physical abuse, are covered through here.
Yes.
That's protocol. Thank you.
Yes.
Thank you. Senator Abbass's question.
Thank you, Mr. Chairman, and thank you for taking my question. I asked this to the representative who introduced this. I have no problem with it being done verbally, but mandating it being done verbally, is there a reason why it's that way? I understand if it's an emergency, you just call right away, I get it. But could it be or in writing as a friendly amendment?
That's the way the statute has always been written, by telephone or in person, is not new. Is it reflective of where we are in 2026 compared to when this was written in 1999? But I will note that this is the same language that's also in the mandatory reporting statute, that there is only, our central intake is a phone call line. And whether it be police, schools, a neighbor, call central intake. So it's an oral, the first line of communication is an oral telephone call.
Well, I understand that you're neutral on the bill. Would you also be neutral on a friendly amendment that allowed the right? I guess I don't want to disrupt things trying to think in the 2026 lens here.
And
I don't have a problem with it as it's written. I'm just saying, looking at it, kind of jumped off as.
And I also wonder too, if maybe the police departments would be able to speak better to that, because I know there is situations in which when central intake is trying to call police dispatch at, whatever time, some small departments don't have 24-hour coverage. And there is a difficulty in finding an on-duty officer to speak to at that moment. And of course, of a level one, level one is based on this child is in imminent danger. We need to meet whoever it is at the hospital, those kind of situations. But there are, according to the way this reads, we still have to report all of them orally to a police officer, past tense ones that happened 10 years ago. And I do think that is a struggle sometimes to find a police officer to speak to on the phone. I will say that, but I think the police can better speak to what some of their barriers are.
Thank you.
Seeing no other questions, thank you very much.
Thank you for your time
testimony.
again. Nice meeting all of you and seeing you
Nice to
again,
meet you.
Senator Rivas.
Does anyone else wish to testify on 767? Seeing none, I will end hearing. I understand. You should hear from writing. Seems weird the other way.
Just
added in writing, just after the verbal,
Okay.
as part of a minimal facts, you have to know for that. But we need to put it in statute, doesn't it?
Yeah, no, I thought it was like, still using the legal.
Representative Rhodes, come on down. You're closing it out.
Thank you, Mr. Chairman. I realized I did not introduce myself last time I was here just a few minutes ago. And for the record, I am Representative Jennifer Rhodes. I represent Cheshire County District 17, which is Winchester, Richmond, Swansea, Troy, and Fitzwilliam. And this time around, I am here to introduce House Bill 1696, passed on the consent calendar out of our committee. I believe it was 11-1. And essentially what we are looking to do is close a loophole that has been discovered when a person is to remain on good behavior. And we are describing, putting a definition to what good behavior actually means. This bill also came at a request to Prosecutor Slaughter that is behind me. She is definitely the better expert when it comes to explaining exactly how it's going to work in the real world, as she has had this happen, which is why the bill is in front of us today.
No questions. Thank you, Representative.
Thank you very much.
Kayla Slaughter.
Thank you, Mr. Chairman. Good afternoon, members of the committee. Thank you, Representative Rhodes. My name is Kayla Slaughter. I am the district court prosecutor for the Campton Police Department, but I also hold intermunicipal prosecution agreements with 4 other police agencies in Lower Grafton County. The gist of what that means is I'm the district court prosecutor for Lower Grafton County. What I'm looking to do with this bill, as Representative Rhodes says, is close a longstanding loophole. On our current summons forms, those receiving them, the defendants receiving them, are required to appear in court and remain of good behavior. In the summons form, the failure to appear in court has criminal penalties. You can be prosecuted and charged with a misdemeanor. It's also codified within our breach of bail statute if you fail to appear. However, what's not codified currently is what happens when you fail to remain of good behavior when released pursuant to one of these summons. The legislature has already said we want you to remain of good behavior, has included that information in the form, but has not given the state the mechanism to enforce that directive. There are just a couple of main points. I have written testimony, which I'm going to hand over to be passed out. But just to highlight a couple of those points that I make within my written testimony is that the passage of this bill would reduce unnecessary detentions. So right now, if you're released pursuant to a summons, you're not physically taken into arrest. It's actually the summons in lieu of arrest statute. So you're not formally taken into custody and searched and detained or infringed in any way other than by saying, here, come to court. So it's less infringement than the bail process. We also don't have a statutory definition of good behavior. So this bill would give us a statutory definition of good behavior. There's certainly a definition that the court uses in practice and which is written on our bail forms. But this would officially codify the definition that has already being used. And then it also clarifies the duration for which the individual is subject to the terms of the summons and any defenses for failing to abide by the terms of the summons. Thank you, and I'll answer any questions, but also pass over to Chief Suckling.
I'm Chief David Suckling with the Alexandria Police Department, and I'm here to represent myself and the New Hampshire Chiefs of Police Association. And I would like to say that there's not much more I can add that Kayla didn't say already, but we do support this bill.
Thank you both. Questions? Seeing none, appreciate you both coming in.
Thank you.
Does anyone else wish to testify on 1696? Seeing none, that'll end the hearing. Want to make a motion? Adjourn? Nope. Second. All in favor of the adjourning motion? Aye. We are now adjourned.